I want to thank you, Henry, for including me and the good work Linda Kelly, Page did, Ms. Stanford, in putting all this together. There was a fellow outside, I don't know if some of you saw him, but he looked like a former president of the United States. And any of you see him? And he came up to me and said, "Look, I want to learn about the new restatement of torts." And I said, "No, it's torts." And he kind of went away, and that was a very interesting introduction. You know that I love you judges, and I always enjoy being here. And this past weekend, it was a sad note, but the judge I clerked for, Judge Metzner, died at 97 years old. And the 2 years I spent with him were an education that exceeded law school. And you also know that I got my first opportunity to talk to judges from Judge Spencer, who was on the Supreme Court of Nebraska. So through my whole professional life, the opportunity to integrate with judges, learn from them, has been a very, very important thing. And I want to mention it, and I particularly think of Judge Metzner, who taught me so much. My failings are my own, but a lot of successes I've had are attributed to the 2 years that I spent with him. The restatement is a huge project, and it was begun, this particular restatement, by Professor Gary Schwartz, no relative, who unfortunately and tragically at a very young age died. It was taken over by Professor Green and also now president of the University of Texas, Bill Powers. And they have done, particularly Michael, because the real rowing came up to him. He's the AW, the actual worker, who put the thing together, and it's of enormous scope if you look at the index that's in your materials. I want to mention a couple areas where I really agree with what they do, and then a couple of areas where maybe I'm not 100% behind it. The duty concept is a good statement of a general principle of tort law. It says that people have a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. And I've thought about this because there's an article that we have outside with respect to duty and how far duty goes. And if you look at the words of the restatement, this article discusses an area that goes beyond the level of the restatement. 3 years ago, I was debating a guy named Dickie Scruggs. Any of you know who he is? Well, he's in jail now, but I learned a lot from him, believe me. And he said to me, when I meet with state attorney generals to hire me to do the job of going after an industry, I don't talk about nuisance. I don't talk about strict liability or abnormally dangerous activity. I talk about one thing. This company, whether it's an oil company or cigarette company or pharmaceutical company, should not be able to externalize the cost of a risk it creates. If it creates a risk and it creates a cost to our society, it should pay for it. And Mr. Scruggs and others have been successful with the use of that doctrine because it makes sense to an AG. He or she can explain it to voters. Why should Pepco be able to place on the voters of this state the cost of an injury? Or why, if people in this state go to Medicare, should that be paid for by the state? And I wrote an article, and I thought about the restatement and duty limits. And the fact is that externalization of risk has no perimeters whatsoever. You could be on an airplane going home. I hope it doesn't happen, but if somebody has a cold on that airplane, and 3 days later you come down with a cold, that shouldn't really be the responsibility of the airplane. And concepts in the new restatement help define where externalization ends. There has to be proximate cause. There has to be a duty owed. There has to be a breach of that duty. And because of time limits, I won't go into each and everything. It's in the article, and to rehash the article in front of you waste your time. But the fact is, the fundamentals of Restatement Third do put boundaries on externalization of risk arguments that are the arguments that are made to the attorney generals when indeed a contingency fee lawyer, an enterprising one, wants to bring an action that has political and legal aspects to it. And I think you'll find that the article is helpful. The Supreme Courts of most states get it. In Rhode Island in 2008, they stopped a case. It was against lead paint companies that at its core stretched nuisance beyond anything that ever was seen. But underlying that was externalization of risk, that the paint companies that made the paint 50 years ago should not be able to externalize a risk. The Supreme Court of Rhode Island said, no, we're going to apply the general principles of tort law here. We're not going to twist, misshape, stretch tort law to amoeba-like proportions that it's never been before, and the case was dismissed. These decisions have a sound public policy basis to them. There is a temptation to use externalization because it has, at least initially, a kind of common sense to it. But the ends don't justify the means of abandoning fundamental principles of tort law. And the new restatement certainly is not a pro-defendant document by any means, but it has perimeters of basic tort law, and they should confine this amorphous doctrine of assumption of risk. I also like that the restatement held a line on something I've mentioned to some of you before on emotional harm when there's the injury or death to an animal. I was talking to one of the judges who has done so much in his career at lunch, and he told me about his love for his dog who he went hunting with. But he could see that when it comes to injury to dogs or pets, that the cost of the animal, other costs should be the line. Now, Henry knows that when I first heard about this and it was brought to my attention, because of my dog, Kylie the dog, I wanted to have emotional harm. If something happened to Kylie the dog, I certainly would feel emotion. I would, Judge. Well, I discussed this with Kylie the dog, and she has this look. If any of you have a pet, when they look at you like you're an idiot, she looked up and said, "You dumb something. Woof, son of a mother dog." She said, don't you realize that if we add emotional damages to a claim, it's going to take a $5,000 or $2,000 claim and turn it into $50,000? What do you think it will do to the cost of my veterinarian, Dr. Peters? And what will it do to people who are trying to innovate medicine? Why, listen, you know, she made some good public policy points. But then she had the clincher. She said, don't you realize if you win this suit, I don't get the money? You know, I could see the argument. And the restatement wisely does not venture out to allow loss of companionship damages. It's a very tempting thing. Supreme Court of Vermont last summer rejected it, not known as a pro-defendant court, in a very articulate opinion. And it may seem trivial, but if that legal change was made, it would have dramatic effect on everybody in this nation who has a pet, because costs would go up in areas that are important, particularly people who are struggling a little bit with money and suddenly see their vet bills pop 4, 5, or 6 times. It may seem minor, but it affects people in their daily life. There are a couple of areas where I have concern, and I think Mike Green and his friends and colleagues did a good job in the restatement. I just don't find it helpful. There is in the restatement an over-relaxation of both causation and expert testimony standards. The restatement begins with the idea of something that everybody can agree with, that the plaintiff should have the burden of proof in showing causation. And I think a division line between cause and fact and proximate cause is a good idea. But in the new restatement, in a section called 28A, if the plaintiff claims that multiple parties caused his harm, the burden shifts to the defendant to show who did what. Now, the way I read it, there is no necessarily showing that each one really did something wrong, clear and absolute evidence that they were all negligent, which was true with that old Summers v. Tice case where 2 hunters in the woods negligently shot at the plaintiff. Plaintiff didn't know who did it, and the burden of proof shifted. It's much bigger if you shift it to a whole group, and there's no clear showing that each one was at fault. And also under the new restatement, and a part that's even more controversial, comment C in 28 makes epidemiological evidence necessary but not nice. And it says often that evidence isn't available for many years, and why should the plaintiff have that burden? Well, there's often an absence of evidence in many things where the plaintiff can't prove defect or the plaintiff can't prove other things. We don't just shift the burden to the defendant because the plaintiff is unable to prove an integral part of his case. And at least in my judgment, a lot of this stuff is gatekeeper stuff under Daubert or Frye and not restatement stuff. I mentioned one other area, and Mike and I have talked about this where I really don't agree. The new restatement puts out what I call a welcome mat for trespassers. Now, a professor at Vanderbilt once said, trespassers are vermin. That was a little heavy, but they're not the most popular people in the world. They come on your land without your permission, with no legal right to do so. And there have been exceptions for children trespassers, people who go along the road. The no duty to trespasser rule has worked pretty well, but and the idea of getting rid of the categories has occurred in some states, but very few states have created a general duty to trespassers. If you own a second home, if you live in an area where there's a lot of land, it's not good. Now, Mike did create an exception for the flagrant trespasser. Now, he left it undefined. And I've been trying to figure out, when I look at trespassers, whether they're flagrant or not. Now, Jay Leno might be able to do a better job than I, but it's a whole new exception, no judicial construction of flagrant trespasser, and I just think it's adding more confusion. I understand the feelings, the views of the professors who put this together, but if you're a railroad, a utility, a person who has a second home, a person who leaves your property for a period of time, it's worrisome if a duty of reasonable care is owed to professors. Yes, the trespasser is going to lose most of the time, but any of you who have ever practiced law know once the duty is there, you're in settlement negotiations, and you cannot simply dismiss a trespasser case. This is a monumental work, this new restatement, and I think in general it should be welcomed by judges. I think all judges should read it. You did a great job in that, and I thought I'd just mention two areas that I thought were pretty good and a couple that caused me some concern. Thanks.
Thank you, Victor.